Cooper was stabbed to death. He wanted to kill women.
Do you really feel, or do you feel after 14 years that our rape and murder is breaking?
Yes, I do.
I knew that she had been shot.
Miami police have changed their statement about a deadly hit-and-run crash. They now say Venezuelan politician Gilbert Caro was the one who ran a red light. At first, police blamed the victim, a 29-year-old man, for causing the three-car accident. However, after looking at dashcam footage, they confirmed the victim had the green light while Caro ran the red light. Caro fled the scene, leaving the victim and his car behind. He has already been charged with leaving the scene, but police say additional charges are expected. The crash along Lejeune Road and Southwest 8th Street on Monday morning left 29-year-old Junior Eugene dead. The family and friends of Eugene are now left grieving as they wonder if their friend's life could have been saved if Caro had stayed on the scene instead of driving away.
You really should have stayed there. We probably would still have him here today. I hope he gets what he deserves.
Later, Gilbert Caro was sentenced to 15 years in prison following a deadly hit-and-run crash. 2 years after the tragic death of 24-year-old UCLA grad student Brianna Kupfer, the man accused of her murder, 34-year-old Shawn Laval Smith, is in court, facing a life sentence without the possibility of parole. Brianna's family was present but left the courtroom when the audio was played. Meanwhile, the suspect, wearing a spit mask due to past outbursts in court, listened quietly without reacting.
Brianna Cooper was stabbed to death 46 times. By that man.
Shawn Laval Smith is in court, facing murder charges for the death of 24-year-old Brianna Kupfer, a UCLA architectural design graduate student. Brianna was working at a boutique furniture store in Hancock Park when she was tragically stabbed 26 times in January 2022. Smith, 34 years old, was arrested 6 days later and charged with her murder. Prosecutors say the evidence against him includes security camera footage from the store, DNA found on the knife, and a voice recorder that Smith allegedly left behind, which captured audio of the crime as it happened.
With her last breathing words, she's just telling him, I can help you, I can help you, I can help you. And he's telling her, it's over. It's over. It's over.
As for the possible motive, authorities have not provided a clear explanation for why Shawn Laval Smith attacked Brianna Kupfer.
You're going to hear from Shawn Smith's own mouth why this happened.
Referring to the voice recordings on the digital recorder left at the store, prosecutors claim it captured audio of the murder as it happened.
The defendant recorded himself talking about his most vile and disgusting and grotesque thoughts about women.
The prosecution claims they have evidence showing that Shawn Laval Smith attempted to find a woman working alone at 6 other businesses near the Croft House before discovering Brianna Kupfer working by herself on the day of her murder.
He wanted to kill women.
The defense has chosen not to make an opening statement at this stage. Shawn Laval Smith has a significant criminal background, including an unresolved 2019 case from North Carolina, where he allegedly fired a weapon into a vehicle with a father and his son in the back seat. Smith is facing a life sentence without the possibility of parole if convicted. A tense scene unfolded outside a court in Providence as police were forced to clear crowds. 2 men are now charged with the murder of a girl, sparking strong emotions from the community. Inside the court, a heavy police presence was required, along with the families involved in this heartbreaking case. The suspects are accused of shooting the girl while she was sitting in a car with her family. The tragic loss has drawn many people to the courthouse, overwhelmed with grief and emotion.
The pain of losing a child is something that no one should go through.
Police had to intervene after an emotional outburst when 19-year-old Amari Cabrera and 26-year-old Shaheem Nathaniel entered the courtroom to face upgraded murder charges in the death of a girl.
Although we have a heated back and forth between individuals within the courthouse. It's important to know and center ourselves in the people that are impacted right now.
Police report that the girl was sitting in a car with her family on Florence Street when gunshots were fired. She was rushed to Hasbro Children's Hospital, but tragically passed away from her injuries.
From what I know is that they went to a local store to get some snacks with their dad. Mom was at home cooking dinner.
A family that was meant to bring their girl to her first day of school today is now tragically making arrangements of a very different kind.
You know, all the other children in our community went to school this morning and she wasn't able to. It's devastating.
Investigators revealed that neither Amari Cabrera nor Shaheem Nathaniel had a license to carry a firearm. During the investigation, police seized 2 ghost guns, untraceable weapons often assembled from parts.
There's people everywhere that are creating them and selling them.
Amari Cabrera, 19, and Shaheem Nathaniel, 26, have also been identified as violators in previous cases.
We must look towards why individuals are in the framework to commit these acts of violence.
President of Black Lives Matter, Rhode Island, Harrison Tuttle, urges state and city leaders to take immediate action in response to this tragic case.
What my hope is that out of this tragedy, we embark on a path both at a federal, state, and municipal level here with Mayor Brett Smiley as a pathway to permanently end gun violence.
Amari Cabrera and Shaheem Nathaniel have not yet been sentenced, as their trial is still ongoing. However, both men are currently facing upgraded first-degree murder charges. They have been ordered to be held without bail. In a case that has drawn significant attention, a man representing himself in court has made unusual claims, blaming external forces for the death of his cousin 14 years ago in Charlotte. The accused, Derek Ward, is said to have manipulated his cousin Brittany Ward's family, using their beliefs to influence them. According to family members, Derek exploited Brittany's mental health struggles, telling them he could help her. Despite her challenges, prosecutors assert that Brittany was able to communicate concerns about her cousin before she died in 2010.
She did not want him in her home.
The family says Ward claimed he could help. Siblings who requested their identities be kept private stated that they witnessed him choking her.
He said he was trying to get the demon out.
One day, when Brittany and Derek Ward were left home alone, the family returned to find Brittany unresponsive. Holding back tears, her brother recalled Derek Ward's explanation of the tragic scene.
She's been fighting this demon for so long, and it's physically attacking her and hurting her.
They say Derek Ward told them not to call 911. Later, the family learned that she had already passed away and had been assaulted.
Male DNA on Brittany Ward's pubic area that includes the defendant.
Ward's ankle chains rattled as he approached the jurors. Representing himself during the trial, he delivered a rambling opening statement that included incoherent remarks, even mentioning ghosts.
It's not supernatural, not paranormal, it's quite normal.
Ward claimed that the bleeding caused Brittany's death and insisted that he was not responsible for the bleeding.
They charged me with stuff they didn't have evidence for.
Ward confronted his cousins while they were on the stand, challenging their testimony during the trial.
Do you really feel, or do you feel that after 14 years that our rape and murder is breaking?
Yes, I do.
The judge repeatedly explained the law rules to Ward, given that he represented himself. Sometimes jurors appeared caught off guard or uncomfortable with some of his remarks. Loran Cole, a man convicted of murder and rape, finally met his fate after nearly 30 years on death row. Cole was sentenced to death for his involvement in the 1994 murder of John Edwards and the assault of Edwards' sister, Pam, during a camping trip in Ocala. Cole and a friend had handcuffed the 2 siblings, resulting in the brutal killing of John Edwards and the repeated sexual assault of his sister, Pam, a student at Eckerd College at the time. In his final moments, Cole declined to make a statement, responding, "No, sir," when asked if he had any last words.
She was able to chew through the cord that they tied her to the tree with, and she came down looking for her brother.
In a statement, the parents of John and Pam wrote, "He does not deserve mercy." They also praised their daughter, adding, "Pam is our hero," and went on to become a wife, teacher, and professor. Meanwhile, back in Pinellas County, some expressed the view that Loran Cole did not deserve the death penalty.
We have life in prison without parole, We have ways to keep people that are a threat to society away from the public.
Lawyers for Loran Cole argued that he had a troubled past, including time spent at the state-run Dozier School for Boys, where he and others allegedly suffered abuse and rape. They also claimed Cole had a history of mental illness and was diagnosed with Parkinson's disease in his later years. These factors were presented in an attempt to alleviate his sentence, though they did not ultimately prevent his execution.
He can't be with us, he can't be among us, but he doesn't have to die.
Critics argue that executions for those on death row in Florida may increase following recent legal changes. Governor Ron DeSantis signed a bill into law that allows a death sentence to be recommended by a vote of 8 out of 12 jurors rather than requiring a unanimous decision. This change was influenced by the failed death penalty jury vote in the Parkland shooters case. While Cole faced execution, his co-defendant, William Paul, is serving a life sentence. The case against rapper Lil Durk, accused in a shooting outside the Varsity, is moving forward after a judge determined there is enough evidence for him to go to trial. Lil Durk, whose real name is Dirk Derek Banks, appeared in court. Police presented video evidence from at least 5 local cameras, including footage from nearby businesses such as a BP gas station and the Varsity. Detectives from both Atlanta and Chicago testified in Fulton County Court, stating that around 5 a.m. on February 5th, Lil Durk and his co-defendant, Devontae Bennett, were captured on camera allegedly involved in the shooting of Alexander Witherspoon, a person known to them.
They were hanging out. They went to a studio to make music.
The rapper and Bennett listened to the evidence presented against them in court. Police explained to the judge that later that night, Banks, Bennett, the victim, and others went to a nightclub, stopped at a gas station, and eventually ended up in the Varsity's parking lot. It was there that Witherspoon claimed he was robbed and shot.
He said his chain was snatched off his neck, and he had $30,000 stolen from him, and they stole the vehicle he was driving.
According to the police, Banks was captured on video firing a gun.
You see Mr. Banks' arm out the window firing several shots at the victim, towards the victim.
Banks's attorney argued that this case was simply a celebrity witch hunt.
Were it not for the celebrity status of these two individuals, then this would be an aggravated assault.
On the day Banks turned himself in, he released a single titled "Turn Myself In," which has since garnered nearly 7 million views. The prosecutor has charged that this case involves more than just robbery and shooting, claiming it is also linked to gang activity. To support this, she brought a Chicago detective to the stand, who testified that both Banks and Bennett were members of Chicago gangs.
Is it possible to continue your affiliation and even commit crimes when you move out of Chicago if you're in a different city or if a different area?
Yes, ma'am.
The judge ruled that there was enough evidence to proceed with all charges against Banks and Bennett, including criminal intent to commit murder and involvement in criminal gang activity. The trial for the man accused of killing Memphis rapper Young Dolph is highly anticipated, with many still wondering what to expect. Prosecutors are expecting a swift trial.
The judge is announcing today that we're sticking with the trial date, and all parties need to be ready for that trial date, September 23rd.
After nearly 3 years, the details of the 2021 killing of Adolph Thornton Jr., better known to many as Young Dolph, are set to be revealed. The 2 accused gunmen, Justin Johnson and Cornelius Smith, are scheduled to go to trial. Although Johnson was initially scheduled for a hearing, prosecutor Paul Hagerman stated that the attorneys agreed it was unnecessary.
We already have a trial date. The attorneys got together beforehand and there wasn't a need for the hearing.
Earlier, a judge approved Johnson's request for a change of venue. As a result, while the case will still be held in Shelby County, outside jurors will be brought in. Prosecutor Paul Hagerman said they expect the trial to last only a few days.
We tend to move fast here in Memphis, so I think we're hoping to wrap this trial up in 6 or 7 days.
The road to this point has been slow. Johnson's trial was initially scheduled to begin in June, but his attorneys informed the judge that experts needed more time to review their evidence. Both sides have remained tight-lipped about the details and proof of the case. When asked how many witnesses the state plans to call, prosecutor Paul Hagerman declined to comment. However, it is believed that Justin Johnson's half-brother, Jamarcus Johnson, who pleaded guilty to aiding his brother in escaping, may testify as part of his plea deal. Additionally, both Jamarcus Johnson and Hernandez Govan, the alleged mastermind behind the killing, have been ordered to attend the trial, though it's unclear if Govan will testify. It has been a long time since the tragic shooting at King Soopers in Boulder, where 10 people were killed. The trial began with opening statements and emotional witness testimonies recounting the events of that afternoon.
Sir, do you understand those rights as I've explained them to you this morning? I need you to answer out loud, please.
Andrew Harner, who was in the courtroom, described the defendant, Ahmad Alyssa, as appearing noticeably nervous and fidgety, particularly during the prosecutor's presentation. Alyssa reportedly focused on the monitors showing photos of the 10 victims he is accused of killing. The case is not just about determining whether Alyssa is guilty, as the defense is not disputing that he committed the shooting. Instead, the core issue is whether he was mentally sane and competent at the time of the attack.
Our position is that we cannot do anything until we are able to fully assess Mr. Alyssa's mental illness.
The prosecution argued that the shooting was premeditated, citing evidence that Alyssa had researched other mass shootings, including those at the El Paso Walmart and in Christchurch, New Zealand. They also pointed out that he had purchased the weapons and ammunition and drove to King Soopers on the day of the shooting. To the prosecution, this planning proves he was of sound mind. However, the defense countered by stating that under the law, someone can be mentally insane while still having the intent to kill. This is the crucial question that the jury, consisting of 10 women and 6 men of varying ages, must decide. In their closing remarks, the defense emphasized that their argument about Alyssa's mental insanity will not bring the victims back, nor will they ask for forgiveness for his actions. They are simply arguing that by law, a person can have intent and still be considered mentally insane. 5 high school students in Michigan are facing charges for allegedly throwing rocks off an overpass, resulting in the death of a man. Kenneth White, a 32-year-old father of 4, was on his way home when a rock struck him, leading to his tragic death. The suspects have all been charged with second-degree murder. Adriana Diaz is reporting from the Genesee County Jail in Flint, Michigan, where the oldest suspect, Kyle Hanger, is being held. Prosecutors believe he dropped the rock. The other suspects are in a juvenile detention facility. They were all prosecuted and are being tried as adults. During the arraignment, the 5 teenage defendants remained expressionless as their lawyers entered not guilty pleas on their behalf. Their grieving families were present, as was the father of Kenneth White, who was visibly affected by the proceedings.
I buried my mother, my father, and my oldest brother in the last 4 years, and this is the hardest thing I've ever did in my life.
Police reported that Kenneth White, a construction worker, was getting a ride home in a Ford Econoline van around 8:30 p.m. when a 6-pound rock measuring about 5 inches wide and 8 inches long was allegedly dropped from an overpass. The rock crashed through the windshield, hitting him in the face and chest. Tragically, he was declared dead upon arrival at the hospital.
Not a prank, it's second-degree murder.
Officials stated that after the incident, the suspects went to McDonald's. Investigators discovered at least 20 rocks on Interstate 75, with one weighing over 20 pounds.
How's your client doing?
Scared. He feels devastated for the victim and the family.
I think there's been a public rush to accept that these kids are bad, that they're almost animalistic, and they should be punished as such.
Your Honor, Mr. Miller understands the serious nature of the charges he's facing.
The suspects could face up to life in prison, but Kenny White Sr., the victim's father, believes that isn't sufficient punishment.
Even if they spend 30 years in prison, they get to wake up every single morning. They still get phone calls from their parents. They still get visitors. My son don't get none of that no more. That was taken away from him for something stupid.
Investigators suspect that the suspects also dropped tires and car engine parts from another nearby overpass, causing damage to other vehicles. They have been denied bail and are scheduled to return to court. a man who murdered a police chief decades ago, has shown no remorse as he seeks a chance at freedom from the parole board. Jamie Richards pleaded guilty to the shooting death of Paxton Police Chief Robert Mortell in 1994. When Richards appeared before the parole board, he seemed both stoic and unprepared, as explained by Christina Hager.
He's coming in here like it's a field trip away from jail.
Erin, the daughter of Paxton Police Chief Robert Mortell, learned of her father's murder in 1994. He was shot in the woods while assisting police in neighboring Holden as they tried to track down 3 robbers. Jamie Richards was one of the suspects. Although he wasn't the one who pulled the trigger, he was convicted of second-degree murder. 23 years later, he surprised the parole board during his first opportunity for freedom by appearing completely unprepared.
How did you prepare for this hearing today?
I didn't. If this is who you are today, I have concerns of who you're going to be out in the community and how you're going to be interacting with the parole officers and people in the community.
Well, you've spent 45 minutes with me, so I suppose that would be an accurate assessment of how I am.
After hearing absolutely no remorse from him, not even an apology, he decides to come in here not prepared, does not care.
Several individuals urged the board not to show Richards any mercy, including the district attorney who knew Chief Mortell and the state police colonel, who was the lead detective on the case at the time.
And the fact he sat here so arrogant and defiant, I don't know how you would expect this man to go into society.
This is an opportunity for you, if you would like to say something to the board, to do so.
No, sir.
Excuse me?
No, sir.
Chief Mortell's daughter requested the board to never allow Richards another parole hearing, but they are unable to grant that request. Depending on their decision, he could return for another hearing in 1 to 5 years. Ronald Gregory, who is accused of killing his granddaughter and wife, appeared before Judge John Hayes.
I've been representing Mr. Gregory privately in civil matters since October, so he and I have a good working relationship. He has always indicated in this matter he did not want to hire an attorney, and I've explained to him my job is to help him. If that's what he wants to do, I'll help him carry out those wishes. If he decides he wants to hire an attorney, we will hire an attorney for him. All the discovery so far has been delivered to Mr. Gregory through me. I have reviewed it. I reviewed it with Mr. Gregory and let him know what the discovery shows. At this point, he's telling me he still does not want to hire a criminal attorney, but he also says he's not sure.
But I can tell you that it's very dangerous for an individual who is not an attorney to face any charge. Even a shoplifting charge is going to carry 30 days in jail. Particularly dangerous for someone who is charged with 2 murders and is facing life imprisonment to represent themselves if they're not an attorney. Do you understand? Do you understand an attorney could be a benefit to you? There's certain very involved and technical. They trip me up sometimes, and I've been doing this for 20 years and practicing law for over 40. There are technical legal matters and motions that can be made, discovery that's already been discussed today. There's questions about mental situations. There are evidentiary issues that may arise. There's just I can't even catalog for you the number of legal issues that exist in a case such as this. But I can tell you that an attorney would be a benefit to you in handling those issues, because an attorney would be trained, skilled, and used to having those. And for you to take those on yourself would be very dangerous. Do you understand that? Do you understand the benefit of having an attorney? Yes, sir, I do. And you understand that there's danger in going forward without it. Do you have any questions about where we are in this case at this time, today?
Where do we stand right this time?
Well, where we stand right now is
being charged.
Big part?
Being charged or being.
Well, I'll have to ask the solicitor a little bit about that, because I know you've been arrested. Obviously, you're in jail. The warrants have been issued. I don't know whether or not you've been indicted and when those indictments have gone to the grand jury. I don't know whether it's been in their hearing. But let me get the procedure where we are procedurally from the solicitor, if you don't mind, because I don't know.
Yes, sir, Your Honor. The case has not been indicted.
We have not received a request for a preliminary hearing in this matter, so we have not scheduled one. If we did receive a request for a preliminary hearing, we could certainly make that happen. No, sir, we're prepared to move forward with this case expeditiously. I think the next impediment, or the only impediment that is in our way right now, is resolving the issue of mental health, knowing that there isn't an issue there, because that could obviously take the case in a different direction. But once we've resolved that issue, if there are no problems there, we're prepared to move forward.
Ronald Gregory was sentenced to life in prison after pleading guilty. On December 21st, 2020, in Atlanta, Kennedy Maxey tragically lost her life to a single gunshot. The pain her mother feels is unimaginable, and speaking during the trial of her daughter's killer brings back overwhelming and heartbreaking memories for any parent.
Prior to y'all stopping, or y'all having a conversation in the car?
Yes, we are. We're talking about getting something to eat.
Was Kennedy's talking part of that conversation as well?
Yes, she was.
And at some point, did something happen?
Yes, we heard some gunshots.
How many gunshots do you recall hearing?
2 or 3.
And what happened at that point?
When we initially heard them, I screamed, "Fuck!" And Kennedy said, like, "Don't say that. It's a bad word."
And then what happened at that point?
I started joking with my sister, not thinking that we were in any real danger. Asking her to drive and to get us out of there.
And what happened at that point when you asked her to get us out of there? Let me ask you, could you tell where the shots were coming from?
They sounded behind us. They were coming from we knew that they were coming from in or around Phipps.
And you said, get us out of here, and what happened at that point?
Jade started inching forward to try to turn. She couldn't because there were cars in front of us that were blocking her access to the turn lane.
At some point, was she able to turn?
She was.
And if you could just show us some spaces in the 2B, in what direction did she turn?
She turned to the right.
And are you familiar with what road that is?
I believe that's Lennox Road.
Yes. Once you all turned, what happened next?
We were just driving again, headed towards 400. At some point, we heard a very loud bang. A gunshot.
What happened after you heard that loud bang?
I heard Jade say something like, that felt too close for comfort, and then I heard a police siren go off for just a second.
Did you see the police officer?
I could see his car to the left of us.
What lane were you guys in when you turned onto Lennox Road?
We had to be in the right lane.
After you heard that big bang, police siren go off, what happened next?
It got our attention enough to where I started to call Kennedy's name to try to get her attention.
And were you able to get her attention?
No, she didn't respond.
When you say you're trying to get her attention, you called her name. Did you do anything else?
So I called her name. When she didn't respond, I looked in the back seat and saw that she was hunched over, and I continued to try to get her attention. Again, I didn't think we were in any danger, and Kennedy was incredibly animated, and so at first I thought she was playing with us, and at some point I saw white foam coming out of her mouth, and so I immediately started thinking she's seizuring, and I jumped in the back seat. I called, I don't remember who first, my mom or my boyfriend, because I just didn't know what to do.
At that point, did you understand or know what had happened to Kennedy?
Yes.
What did you know?
I knew that she had been shot.
And what did you base that on?
Based off of the wound on the back of her head.
After called your mom. What happened at that point?
Probably in the midst of me talking to my mom or my boyfriend Ryan, Jade was on the phone with the cops. I am begging and pleading with Jade to stop driving because she didn't know where she was going. And we had heard that police siren, so I figured if we stopped, then we could get some, I figured he was around, we could get his attention.
Did Jade stop?
No, she never stopped.
What direction was she driving at that point?
She was on Lennox driving towards 400 North.
Did you, at some point, did y'all get on 400?
Yes, we did.
And where did you go?
We drove until the next time we stopped, we were at the hospital.
What hospital?
Scottish Rite.
What happened when you got to Scottish Rite?
Jade immediately jumped out the car and she opened the back door and she was making a bunch of fuss, and she ran into the hospital and she came out and grabbed Kennedy, and some doctors and nurses came out to carry Kennedy inside.
Let me ask you, when you guys heard the gunshots when you were on Peachtree Road, did you hear or feel anything in the car? Did you hear any glass break, ding on the car, or anything of that nature?
No.
Once you turned onto Lennox Road, you what you described as a big bang, did you hear any glass break or anything that felt like it was hitting the car?
No.
Once you get into Scottish Rite, what happens at that point?
They take Kennedy into a room. There's a bunch of doctors and nurses in there, and they were examining her, and it appeared prepping her for surgery, or what I would assume to be surgery.
During the time that you were in the car in the back seat before you got to Scottish Rite, did Kennedy ever say anything to you again?
No.
Was she breathing?
Yes.
And you indicated once you got to Scottish Rite, they began to prep her for surgery.
Mm-hmm.
Did she have surgery?
She did.
What type of surgery did she have?
They removed the right side of her skull.
Do you know why?
To allow for her brain to swell, to have room to swell because of the wound.
How long did Kennedy remain in the hospital?
For 5 days.
During the time that y'all were at the hospital on December the 23rd, did you ever speak with police?
I did.
When did you speak with police?
The first time I talked to an officer, Kennedy was in surgery. And the second time I talked to Detective Agan after Kennedy had got out of surgery.
Was that all on December the 21st, 2010?
The initial conversation was on December 21st when Detective Agan came in. It was late. I don't know if it was on the 21st or early the 22nd, after midnight.
When you spoke with Detective Agan, what did you tell him? What did you tell Detective Agan?
I told him about, our day, how we ended up in the area. I told him about hearing the initial gunshots and then the gunshot on Lennox Road. And I emphasized that I didn't know exactly what had occurred to lead to Kennedy really getting hurt.
My sister and my family and I have been living the unimaginable, trying to find the words to write a victim's impact statement for my perfect 7-year-old niece, who was stolen from us in the most tragic way during Kennedy's favorite holiday season, exactly 1 month before her 8th birthday. Unimaginable. It's really the only word to describe our family's reality. A reality that we are stuck with for the rest of our lives. A reality we had no say in. Due to the defendant's blatant disregard on human life, Kennedy is no longer here with us. In unimaginable pain. Kennedy was the most special little girl who would choose her tablet over TV, the pool over the beach, and Daddy's house over school. On December 21st, 2020, the defendant took Kenny's right to choose. She had a whole life of choices ahead of her. Again, I could never imagine having to ask. Your Honor, I ask that you consider the precious life of my beautiful niece and all that was taken from her when sentencing the defendant today. Please consider the unimaginable pain my sister feels every day being without her baby. Please consider our family's unimaginable reality.
A mother is never supposed to bury a child. A grandmother is never supposed to bury a grandchild. But on January 2nd, 2021, I witnessed my baby bury hers. Kennedy McCall Maxey, a beautiful, funny little diva that loved Taco Bell. She would order tacos, no salad, and she would say, just 6. The Simpsons, the yellow people as she called them. Her tablet, and most of all, her family. Kennedy was my oldest grandchild and my only granddaughter. I never would imagine having to ever say goodbye to her. Christmas was her favorite holiday. We would even joke she loved it more than her own birthday. Kennedy, her mom, looked forward to Christmas every year. A day that should be filled with love, excitement, and happiness has been changed for our family forever. Christmas Day 2020, when Kennedy should have been enjoying opening presents with her cousins and playing with her new lap out LOL toys, she was in the hospital bed fighting for her life. A memory that is forever engraved in my mind. Kennedy's favorite holiday is now filled with the overwhelming amount of sadness, grief, and anguish. A day our family thought would hold generations of family traditions in a now dreadful day, where we were forced to remember not only Kennedy's last Christmas with us, but her last day forever. Our family was robbed of being able to experience what would have been many of Kennedy's firsts. Her unborn brother was even robbed of being able to experience having a big sister. My daughter Mariah was robbed of her entire universe. Kennedy was robbed of her beautiful, bright future. A piece of my daughter left with Kennedy. She will never be the same. Having to witness my daughter try and carry on while staying a good person has almost unbearable at times. Knowing as her mother, I am helpless. Knowing I can't give her her baby back or say anything that could truly console her. While watching the defendant show no remorse or regards to my grandbaby's life, I'm asking the courts today to impose the maximum sentence punishable by law on the defendant. Thank you.
Okay, I would like to tell you about what I have been doing while I've been incarcerated. I volunteered to go to the New Beginnings program to get my GED, which I will be taking my test on September 21st to help change my life. I have completed a lot of what we have in this program so I can be a better person. And the things I've learned are the 12 steps to your addiction. And that your addiction is not just drugs. It could be the lifestyle of love and how to overcome your addiction. And adapting to change and why it matters. And understanding self-destructive behavior. These things are very important on how to overcome the things that mislead people. And I'm using the things I've learned to determine my will-being in life. I know I have been convicted of very serious charges, and I'm not asking for a slap on the wrist. I'm asking you to consider giving me a possibility of parole in my sentence. I have planned goals and programs to help me get incarcerated, which is finishing my GED, any anger management and rehabilitation programs, along with any integrity or motivational programs. I'm a better person. I will do whatever I have to do to strive to be successful while I'm incarcerated. This situation is very devastating and hurtful, and I have a heart. I was a victim of crime in my situation as well. And I want to apologize for what my grandmother said over the phone. She was very upset and said things that were wrong. She even told me to kill myself.
Okay, members of the jury, I understand that you have a verdict. Is that correct? And who is your foreperson? All right. The court has reviewed the verdict for. And sir, if you will publish the verdict by starting at the very top, reading the caption all the way down to, I believe it's page 2 or page 3, whichever one, including the date as well as your signature, okay?
Okay. Starting the state of Georgia.
Hold on 1 second. Sir, will please rise for the verdict?
Starting the state of Georgia.
Yes, sir.
State of Georgia v. Daquan Reed, criminal case number 21 SC 179260. The verdict: count 1, murder. We, the jury, find the defendant, Daquan C. Reed, guilty. Count 2, felony murder. We, the jury, find the defendant, Daquan C. Reed, guilty. Count 3, felony murder.
Okay, and is it signed and dated by you, sir?
Yes, it is.
All right, thank you. If you'll please stand back to the left for me, please. If you'll please show the verdict form to the state and the defense.
The accused should face a severe punishment to serve as an example for society and to discourage others from committing similar, terrible crimes.
Considering the appropriate sentence to be given in this case, the state has talked a lot about motive and why Mr. Reed may have chased after the person who allegedly robbed him, why he may have fired that gun out into traffic. I personally don't really care. I don't care what his reasoning for doing it was. As a convicted felon, Mr. Reed chose to carry a gun based on the social media that was introduced at trial, continuously and repeatedly carried multiple guns or was in possession of different guns. He chose to bring that gun to a public and crowded mall right before Christmas. He chose to respond to the alleged robbery, not by getting law enforcement involved and taking the appropriate actions, but by chasing after the alleged robber with all of his friends and firing that gun out to a crowded city street. And that bullet is what resulted in Kennedy's death. Up until today, Mr. Reed has shown no remorse whatsoever. Based on the evidence that came out at trial, he showed no remorse after he found out that his actions of firing that gun into traffic resulted in Kennedy being injured and eventually dying. Instead, he responded by trying to get rid of that gun and then trying to get another gun. Immediately. He showed no remorse during trial. He showed no remorse after even being convicted, when his grandmother on the phone with him made threats to commit very egregious acts of violence in his courtroom during sentencing, and he responded by laughing on the phone. Up until today, there's been nothing. So I understand his expressions of remorse now, but take into consideration of his actions that led to this murder and his actions after the murder, his actions during trial and his actions after the conviction, I do not find that mercy is merited in this case. The sentence of the court with regard to count 1, murder, is life without parole. The sentences for count 2, 3, and 4, felony murder, will be vacated by operation of law. The sentence for count 5, aggravated assault with a deadly weapon, will merge into count 1. Count 6, criminal damage to property in the first degree, will sentence him to 10 years, but that sentence will run concurrent with count 1. Count 7, possession of a firearm during the commission of a felony, 5 years consecutive to count 1. And count 8, possession of a firearm by a convicted felon, 10 years consecutive to count 1, for a total of life without parole plus 15 years.
Daquan Reed, the man convicted of murdering Kennedy Maxey, was sentenced to life in prison without the possibility of parole, plus an additional 15 years. Reed was found guilty on multiple charges, including murder, felony murder, aggravated assault with a deadly weapon, and possession of a firearm by a convicted felon. In 2012, Isabel Celis was tragically murdered in Tucson. 5 years later, in 2017, Christopher Clemens was arrested for the crime, reopening the emotional wounds for her family. During the trial, Isabel's mother broke down in tears as she recalled the horrific fate of her daughter. The extent to which these expressions of grief reached Clemens remains unknown only to him.
You know what? We have all day, just so you know, and literally we have all day. I have nothing else on my calendar. You take your time. If you want to take a break, we'll adjourn and come back, all right?
Yep.
All right?
Okay. The actions of this man have caused so much pain and suffering to so many children and families, including my daughter, Isabel, my boys, my husband, me, and our families and friends. Isabel's favorite place in the world was home, and he ruined that for her brothers, for us, her parents. We could never see that place as home again. He took Isabel's childhood away from her, along with my boy's childhood. His actions causes so many events of anguish, heartache, accusations, scornfulness towards my family that we had to endure. His actions took Isabel from her brothers. He took away a beautiful life presence. We will never get to see her grow into a beautiful woman, to watch her grow up, graduate high school, go to college, get married, and all the things we will never get to do with her. Christopher took her and killed her. In my opinion, Christopher has no remorse, no feelings for his actions. He has hurt countless children and families, including Isabel, Maribel, my boys, my family. His punishment should be natural life and no parole. The problem is he will do everything to cheat the system through appeals to get away with all his crimes, and maybe one day he will succeed. My solace is knowing in the Bible there is a verse in Matthew. If anyone abuses or hurts one of these little children, these little ones who believe in me, it would be better for him to have a heavy boulder tied around his neck and be hurled into the deepest sea than to face the punishment he deserves. The Bible speaks of God's wrath, and it has been shown to be great. He has hurt many, many little ones, including my baby girl, Isabel. Punishment in this world will never be enough for the amount of pain and suffering he has caused. God, karma, Mother Earth, whatever you believe in, all of this has a way of making things right that no one can escape. Christopher Clemens should get natural life to have time to process God's wrath that is unescapable.
Thank you, Ms. Phelps. You'd be proud of you.
Your Honor, when the prosecution brought to us the death penalty that was on the table initially in this case, they asked us how we felt about that. We both felt that we didn't have the say of who lives or dies. Clearly, there are others that feel above that. The death penalty was off the table. We, my son Julian, Sergio, Becky, and myself, we all are going to serve a life sentence of this unescapable, never-ending nightmare. Myself, until the day I die, I will feel responsible for not doing my job and protecting my little girl from the evil that lurked outside her window. Please hear my wife's words. Let justice prevail, Judge.
Judge, I think for Julian and the family, I will get through this if Your Honor's okay with
Absolutely.
reading it. Dear Isabel, I love you with all my heart. I really miss you, and I want you to come home to us. I'm really sorry for being mean to you. I want you to come home so that I can treat you with more respect and more kindness. I wish that this never happened. I miss you being kind to me. I now know that when you were very nice to me, but I was mean to you, that was not fair. I wish I could tell you how sorry I am to you. I love that you loved me very much. I'm very sorry that I acted like I didn't even love you. I wish that this never happened to you, because now that you left, I've been wanting to go look for you when I found out that you were kidnapped. I cried so much. I am very sorry that this happened to you. I'm hoping that we find you soon, because I miss you very much. I wish that you were home right now. Whoever took you, have mercy on him or her. I hope you come home safe. By the time you come home, I will cry very much. I will be very happy. I will cry so much because you've come home. I will hug you, make sure that nobody comes and takes you again. This person that took you hopefully gets in big trouble. I love you with all my heart. Judge, the state is asking for a term of natural life consecutive to the natural life sentence this court imposed on Maribel Gonzalez's murder. You have this defendant's criminal history, which is detailed in the pre-sentence report. I will say, and I know that probation is busier than I've ever seen them, Judge, and I know the PSR notes that they were not able to get a hold of the advocates or reach the Celis family. For the record, and Your Honor knows, they are here all the time. They've sat through 2 trials. They addressed the court today. Yeah. So just for purposes of the record, I want to make sure that that portion of the PSR is corrected or reflected. You have had a chance to see this defendant's criminal history, not just here, but the many priors that he has for burglaries in Maricopa County. You had additional letters that family and friends submitted to Your Honor to consider and review. What is most prominent in aggravation is the emotional harm that the Celis family endured in this case. April 21st is coming up in just a couple of weeks. I saw something this morning where the sentencing meant closure for this particular case. And perhaps for the community who's watched for the last decade. The abduction, the 5 years that it took before Isabel was found, and the sentencing here today may bring some closure. It is never going to be closure for this family. And you heard Sergio and Becky address you today, her brothers, who've also been here. What was ripped from them, what was stolen from them on the morning of April 21st can never be replaced. Whatever sentence you impose for this defendant will never replace Isabel to her family and friends. I don't believe there's any mitigation this defendant can proffer that would outweigh the aggravation, his criminal history, and certainly the emotional impact to the Celis family.
I find it disturbingly ironic that at the nascence of each of the last 3 trials in which I've been a defendant in this court, Mr. Martin, you have, in baronial locution, lectured the jury about the importance of a fair trial being afforded to every citizen of this country. You stressed to the jurors that if these rights so enshrined in our Constitution were not adhered to, quote, we are lost, unquote. Using Joseph Stalin's show Trials of the Soviet Era, who attempted to illustrate trials of the United States nomenclature as being diametric to the iniquitous nature of those conducted at the behest of the late Russian dictator. Mr. Marner, I'm unsure if you were simply repeating some platitude you gleaned from law school or the History Channel in an effort to embellish the verisimilitude of your court. or if you were offering a tacit acknowledgement that the proceedings thereto overseen by your predecessor, and from that point to jury deliberation overseen by yourself, would be anything but fair. Either way, all 3 trials that I've endured in your court would have no doubt made any Soviet chairman of the Council of People's Commissars proud. It's inconceivable how any person with even a semblance of pragmatism or objectivity could call what just happened a fair trial. Mr. Martyr, maybe you believe, like countless others, that a trial is fair so long as it takes place in the United States. Or maybe, also like countless others, you don't practice what you preach and instead embrace the ever-growing ideology that the end justifies the means and all else in between is nothing but ceremony. With alacrity, you saw that these trials took place even though the case was saturated with substantive rulings left by a judge, your predecessor, who was found to be biased by the Judicial Conduct Commission. You denied to even look at these rulings unless, of course, doing so would benefit the prosecution. You denied a change of venue even in light of the fact that this city's collective media had chose to supplant calumny for veracity and propagate guilt into the community's minds long before these trials ever even commenced. And it was you, Mr. Martyr, specious champion of the American citizens' right to a fair trial, that actually had the temerity to commiserate with jurors after a hung jury and inform them of my record and previous conviction begotten in your court. You assured those jurors that I would not be getting out of prison. Your sentiments and bias went from your very mouth to those hung jurors, and from them to the media. And the media, our so-called fourth estate, didn't hesitate to put what you said to those jurors into print and television as cannon fodder for the next jury. Your actions helped ensure that a guilty verdict in the next trial was all but certain. The trials and the hearings leading up to them are the best examples of confirmation bias I've ever seen. And I've read a lot of books about village hangings carried out by the Crown in the Middle Ages, Hitler's fascist government, Pol Pot and his ruthless Khmer Rouge regime, and yes, Joseph Stalin's purges and show trials. I still maintain my innocence, even if such innocence has never been presumed by anyone in this court or the community in which it operates, other than my attorneys and maybe a few people too afraid to utter such an outre belief. Though this experience has tested my trust in the American justice system, I still believe in this system constructed by our founding fathers. It's not perfect, and those good men knew as much. They knew that injustices and unfairness of courts like King George's and in countries like Spain and France could insidiously make their way onto American soil. It's one of the reasons why we have appeals, Mr. Martyr, because of judges like you. Maybe in your next perennial discourse to a jury about what isn't a fair trial, you should contemplate using the trials I endured in you and your predecessors' courtrooms as an exemplar instead of Stalin's slightly fair kangaroo hearings. In closing, I'll quote your words, Mr. Martyr, words that eerily mirror those of a German journalist who watched in dismay as men in brown shirts lurked toward the newspaper she worked at in Berlin circa 1934. Quote, "We are lost," unquote.
All right. I find the defendant guilty of count 1, first-degree murder, class 1 felony in violation of ARS 13-1105, committed on or about April 21 of 2012. I find the defendant guilty of count 2, kidnapping a minor under 15, a dangerous crime against children, a class 2 felony, non-dangerous, non-repetitive, in violation of ARS section 13-1304, and 13-705, 13-3821, committed on or about April 21, 2012. The defendant guilty of count 3, burglary in the second degree, a class 3 felony, non-dangerous, non-repetitive, in violation of ARS section 13-1507, committed on or about the 21st day of April 2012. The court enters the judgment of guilty, saying the court has weighed the information available to it. And Ms. Miller, while I understand your position regarding comments made that weren't presented to the jury but were made during the interview with the FBI agents, I'm not going to consider them for purposes of sentencing. I'm limiting my consideration strictly to the evidence that was admitted at trial and heard by the jury. That being the case, I think everything pales in light of victim impact. Again, not my place to go on, but I think Mr. and Mrs. Sells did a fine job. The record's been made. I do find that, as to count one, I do find a natural life is warranted. I'm going to order that Mr. Clemens, you're sentenced to natural life in prison without the possibility of commutation, parole, release, or any other relief. As to count two, kidnapping a minor under 15, a dangerous crime against children, I'm going to order the presumptive term of 17 years be served. And as to count three, burglary in second degree, I'm going to order the presumptive term of 3.5 years to be served, concurrently with the natural life sentence for count one. These sentences shall run consecutively to the natural life sentence and other sentence imposed on counts 4 and 5 in this matter. They shall run consecutively to the sentences imposed in Maricopa County under cause numbers CR 2017-005669, CR 2018-00917. Fines and fees, I will order the $500 forensic assessment, $2 victims' rights enforcement assessment, $9 victims' rights assessment. Counsel, oh yeah, that's right. $500 forensic assessment, $250 offender registration fee assessment, $50 address confidentiality program assessment. All other fines and fees are waived. Stating clarification, court's ruling.
Not of your ruling, Judge.
No, Your Honor. Thank you.
Very well. Mr. Clemens, you can challenge what I did by filing a notice of appeal. It must be filed within 20 days of today's date. Anybody need to make any further record on anything?
I do, Judge. I would ask.
Oh, restitution? I forgot about restitution.
I don't think that anyone is asking for restitution in this case. So if you want to leave it open, Judge.
I'll leave restitution open for a period of 1 year from today's date.
Thank you, Your Honor. During Mr. Kessler's comments, he referenced a email that I had received from a juror. I don't agree with the comments he made. I think it was exactly to the contrary. So I'm going to ask that that be made part of the record, even if the court wants to put it under seal.
No, very well. And it was, actually, I'm glad you brought that up. I hadn't already filed that under seal.
I don't know, Judge. I know that there were a series of things, but just for purposes of the record, I want to make sure that that email is included.
Yeah. I was thinking the exact same thing when Mr. Kessler was making that comment. What I will do is, I think my J is in here somewhere. Do we have a copy of that email?
Yes, sir.
Okay. So what I will do is I will file that email under seal. Any objection, Mr. Kessler, Mr. David?
No, Your Honor.
Yeah, and I will file it under seal and have it be part of the record. And it can be subject to appellate review.
Thank you, Judge.
Hey, that's a good thought. Thank you. Anything else?
No, Your Honor.
Anything else?
Nothing further.
As I said earlier, and this is for the lawyers, it's a pleasure working with professionals. So thank you for your camaraderie and your assistance. And I'm proud of you, both sides.
Thank you.
Okay. And unless we have anything else, we're adjourned. Thank you all.
Christopher Clemens was sentenced to natural life in prison without the possibility of parole for the murder of Isabel Celis. In addition to the life sentence, he received 17 years for kidnapping and 3 years for burglary related to the case. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.